So this next panel on religion and the administrative state will be moderated by the Gray Center's Deputy Director, Andrew Closter. He's on his way in. He's been detained by something briefly. So let me introduce the author of this panel, and we'll move forward. Today we're here to discuss Mark Rienzi's new paper, Administrative Power and Religious Liberty at the Supreme Court. Professor Rienzi is a visiting professor at Harvard Law School, senior counsel at Beckett, and professor of law at the Catholic University of America's Columbus School of Law, where he specializes in constitutional law, religious liberty, and the First Amendment. Mark, thank you for this paper. Welcome, and please begin.
Great, thank you, Adam. Thanks very much to the Center. It's an honor to be here and to be here with such distinguished panelists, and thank you to you all for being here to talk about these important and difficult topics. Just to give my usual disclaimer, as Adam mentioned, I have a lot of different bosses. I have a lot of bosses and a lot of clients. The views here are mine, not theirs. Let me start by just giving a brief roadmap of what I'd like to do for about 10 minutes or so here. Basically, I just want to give an overview of one way to think, at least the way I have now started thinking about the conflict between religious liberty and administrative power at the Supreme Court. So basically, there's really three areas I want to hit. One, I want to show a couple of slides, which I don't think will surprise anybody, but that will give us a way to visualize how much more conflict there has been between religious liberty and administrative law at the Supreme Court in recent years than there was, say, in the first 100 years of the court's religious liberty jurisprudence. So one is just an overview of an easy way to visualize. Let's look at how much more conflict there is. Two, I want to talk just briefly about some reasons that kind of conflict probably is arising. I don't think those reasons will be terribly surprising or controversial. And then three, I want to spend the bulk of the time talking about why this conflict matters. In other words, why does it matter? How might it matter that the Supreme Court these days is deciding religious liberty cases more and more frequently, where the source of the government power that creates the conflict is administrative power rather than legislative power. So now I'm going to see if I can use this thing. Look at that, I can. And even though I said I was going to sit at the table, I'm going to move over here so I can point things out as I go. So what I did was I basically looked back at all of the key free exercise cases since 1878, since Reynolds, the Mormon polygamy case, and tried to categorize what is the source of the conflict here between religious liberty and the government. Is it legislative power, a statute that a legislature has passed that's causing the problem, or is it an action of some administrative agency? Or sometimes it might be both. And admittedly, these categorizations are sometimes somewhat vague and eye of the beholder. That said, as I looked at the first 100 years, what I noticed is the vast majority of the conflicts were legislative conflicts. So if you think about something like Reynolds, the conflict was Mr. Reynolds was a Mormon, and his view was that God had told him he should have multiple spouses. The state of Utah had a law, which Congress made them have, which said, sorry, no plural marriage, right? It was a conflict between a legislative enactment and somebody's religion. The vast majority of cases in the first 100 years fit that mold. As a few people today have already pointed out, there are some exceptions. The pledge cases are big exceptions. Gobitis, Minersville School District versus Gobitis, and West Virginia Board of Ed versus Barnett. Those are cases where it really is an administrative decision, ultimately, of the Board of Ed to say every student must salute the flag and every student must say the pledge. And Employment Division versus Smith, which really, truly is an administrative case also, where you've got the State Unemployment Board deciding that using illegal drugs counts as misconduct. What I found to be really fascinating in looking back at these old cases is that even where the cases involved administrative power, the judges, by and large, talked about the cases as if they were legislative. So if you look at a case like Gobitis, throughout the case, the court repeatedly talks about whether somebody's religion can trump the will of the legislature, can trump the legislative majority's decision. Barnett speaks in that language quite a bit. And of course, in Employment Division versus Smith, which is an administrative case, Justice Scalia seems to go out of his way to present the case as if it's really a conflict between religion and the State's Controlled Substances Act. So again, for the first 100 years, where much of our free exercise doctrine gets decided, the cases are, by and large, very much legislative cases. There are a handful that are administrative, other than the unemployment cases like Hobby and Sherbert v. Werner, unlike those, except for those cases, most of them the court talks about them as legislative, even when they're administrative cases. If you look at the more recent period, so the last 40 years, you see many more administrative cases. Hobby Lobby, Hosanna Tabor, Ling. Many more times in recent years, you get administrative power causing the conflict, much more so than legislative power. Sometimes they're mixed. And then if you take a snapshot of just the last 10 years of cases at the Supreme Court, which is a tiny sample, so just to be clear, these are gross overgeneralization slides, right? The whole sample here of all the cases is like 35 cases. In the last 10 years, it's like 6 cases. Gross overgeneralization, but still I would suggest a useful gross overgeneralization in that it shows that the Supreme Court is really looking a lot at religious liberty claims arising from the administrative context. That's all I have for slides, so I'll come back here to finish. None of that surprised me when I sat down to categorize the cases and see where are these conflicts coming from. I think most people intuitively have the sense that the administrative state is much larger than it used to be and ends up causing more conflict. Why might the administrative state be liable to cause conflict with religious groups? I don't think any of these observations will be surprising, so I'll just make them really quickly. The administrative state is very, very big. They issue lots of regulations. There are tens of millions of people who go to work each day in administrative agencies, for state, local, and federal government. A lot of government employees, many of them at agencies, they need to do things. What they do is they regulate. That ends up causing conflict. Agencies, by and large, are large. They can be very powerful. They can be far-reaching. They can be flexible. They can have a million tools in the toolkit. Agency actors tend to be specialists. If you work at the Board of Education, you think my job is to educate people. If you work at the Department of Health and Human Services, at least one of your primary tasks is health and human services. So you have specialists tending to populate agencies. And I just want to pause and compare that to the people who make legislative law, right? Generally speaking, your legislators are by definition generalists, not specialists. They have to get support from a broader range of people to get the job. They have to legislate on a broader range of issues. I think by definition, they are more likely to balance and take into account competing views and competing issues than might be the instinct of people working at an agency. So I think all of those things may contribute to the increase in conflict. And to be clear, I'm not taking the position here that those attributes of agencies are necessarily bad. I certainly think there are plenty of ways in which they can be bad, but specialization is not inherently bad or wrong. Government action by agency power is not inherently bad or wrong. Sometimes they can do good things. But it's clear that over the past several decades, they've been doing more things that run into conflicts with religion. And so what I'd like to do for the last few minutes here is just talk a little bit about what's going on with the doctrine and what we can expect as we think about a free exercise doctrine that gets developed in this context of agency power and religion. One thing to think about this conflict is that the massive growth of the administrative state and of government generally does include a lot of situations where you have areas that religious groups used to do on their own that suddenly become government turf in some way, or at least heavily government regulated. If you think about things like education, foster care and adoption, health care. Religious groups were actually doing these things long before governments were in the United States. And as the agencies come in and impose their rules, you can imagine you end up with conflict. Okay, what should that mean for the doctrine? Let me start with the example of the contraceptive mandate cases, the Little Sisters of the Poor case, also Zubik and Hobby Lobby, because I think they demonstrate a useful thing to think about with these increasing conflicts. And that is that the same attributes of agencies that make them likely to crash into religious liberty, the fact that they're big and they're far-reaching and they have a lot of tools in the toolkit and they're specialized, those attributes also mean that agencies should usually have ways at their disposal to work around religious interests. And so if we just take the contraceptive mandate and the Little Sisters of the Poor as one example, one of the reasons the federal government kept making their arguments, but they kept failing at the Supreme Court to convince the court. One of the reasons is that it was always clear, and it became clearer as the cases went on, that of course the federal government has lots of ways to deliver contraceptives to people without the involvement of nuns. If you imagine the agency sitting down on day one and saying, how are we going to get contraceptives to every woman in America, it would be a while into that discussion before someone raises their hands and says, well, let's call the nuns. Like, the nuns will be really good at that. It's just not, it's not all that plausible. And the reason it's not all that plausible is that the federal government has lots of ways that it gets contraceptives to people already, right? It gives contraceptives to millions and millions of people through Title X programs. It, especially after the Affordable Care Act, it operates these massive government exchanges where the whole point is, hey, you don't have to get your insurance from your employer. We, the government, will create a marketplace for you to get, and we'll subsidize your participation in the marketplace. Governments have lots of tools in the toolkit. So the same attributes of the agencies that lead them to bump into religious interests, I think, will very often mean that they should lose religious liberty cases, because agencies will almost always have less restrictive means available where they can achieve their goals. Again, this is not something that stops them from achieving their goals. They can achieve their goals, but they can work around the religious interest. In 2016, at the Supreme Court, Donald Verrilli, the Solicitor General for the Obama administration, acknowledged to the Supreme Court that women who don't get contraceptives from their employer will ordinarily get them from lots of other places. And they said you could be on a family member's plan. You can go on one of our lovely exchanges. There are a lot of different government programs, state, federal, and local government programs that can provide them. So once they acknowledged that there are lots of other ways to do this, that you don't really need the nuns, it became pretty clear that they would and should eventually lose the lawsuit. So one point about agencies is just the fact that they have so many tools and such far reach actually means they ought to be able to work around religion. And to the point about the cases, it also means they're going to lose most of the cases, which they have been doing. A second impact on the doctrine that I think we're likely to see as we see more and more of these administrative cases is if you think about the premise of the free exercise doctrine that we get from Employment Division versus Smith, the whole case is set up as a battle between individual decision-making, sort of individual conscience and the claim that that might lead to anarchy versus the will of the legislative majority. And Justice Scalia even says, well, even though religious minorities might fare worse in that situation, that's kind of the price we have to pay. But he also says you can assume that the legislatures will also continue to be protective of religious liberty, that's a value that they'll protect. One of the things that I think we've seen happen, though, is that as agencies are more and more the cause of these conflicts, you see situations where it's obvious that there are other values that are coming into play that the agency just ranks more highly than religion. And so if you think about the Affordable Care Act, again, the provision for grandfathering. If you remember President Obama trying to sell the Affordable Care Act, if you like your plan, you can keep it. Right, the grandfathering provision. Well, any plan that was grandfathered was exempt from the contraceptive mandate. The agencies thought that was fine, but they didn't think it was okay to give the Little Sisters of the Poor a similar exemption. Right? There were a lot of other aspects where the agency seemed to value other things more highly than the religious liberty interests. So as the agencies are the ones causing these conflicts, I think we're going to see more cases that fundamentally undermine the idea from Smith that we're getting a lot of neutral and generally applicable laws. I think a lot of times when agencies act, what you have is not a neutral and generally applicable law. Instead, what you have is specialists who have decided that they can order and value things in a certain way, and where religion happens to be losing. If that's the case, those will tend to be cases that over the long haul, I would expect to lose under the free exercise clause. Last aspect of this conflict that I'll flag is just something that Judge Duncan brought up a little bit in his talk, the problem of deference. And on one hand, these cases aren't Chevron cases, as the judge mentioned. But on the other hand, I think judges are used to Chevron cases. And so when judges see agencies, I think they have an intuitive, sometimes spoken, sometimes unspoken, desire to defer to the agencies because they're experts. That's a problem where you're balancing sensitive constitutional rights on the other side. Agencies are experts in some things, but they're frequently not experts in religious liberty or in the religion of the particular minority group who happens to be on the losing end of the decision. That can lead to some embarrassing results, and I'll just do one from the contraceptive mandate cases. Richard Posner, recently retired Seventh Circuit judge, obviously a brilliant judge. Right? I've never heard anybody challenge whether Richard Posner is a brilliant man. Brilliant guy. When he's analyzing the contraceptive mandate cases in the Wheaton College opinion, he goes on, he must say it 7 or 8 times, and says, well, the fundamental problem here is that the religious people are saying the government's trying to use their plan. And the one thing that's clearer than anything is that no one's trying to use your plan, so your whole claim fails. And he says this over and over and over again through the opinion. And this is the summer of 2015. A couple months later, the case gets to the Supreme Court, and the federal government admits, actually, we're using their plan. They just come right out and say, actually, it's all part of the same plan. And so what you have is a situation where judges, I think, will be tempted to defer to agencies. But as the case gets litigated and it gets fully played out, and you get the full spotlight on the government's arguments that you get once it gets to the Supreme Court, I think those decisions often look a little bit silly in the rearview mirror. Same thing happened in Holt v. Hobbs, the Muslim prisoner Beard case. The lower court and the Eighth Circuit had been incredibly deferential to the prison authorities' claim that we can't let this guy have a half-inch beard. Because otherwise there'll be anarchy and danger, never really factoring in the fact that essentially every other prison system in the state had done it, the feds did it, and nobody ever had any problems. So I think the deference problem is one where there's a temptation to be deferential to agencies, but often it's going to backfire on the courts. Let me end with what I think is the good news. So I think we're going to continue to see this kind of conflict. I don't think that's great. But I think one of two things will happen. Either the agencies will not change, and the agencies will continue to create this conflict, and we'll keep having cases, and the agencies will keep losing the cases, because the agencies often should lose these cases because they have other ways to achieve their goals. If that happens, I don't think that's ideal, because I don't think the conflict is a great thing, but I think what we will see is we'll continue to stack up good religious liberty precedents that protect people going forward. But I think the better path, and the one that we may be starting to get on, is one where agencies actually learn the lesson from the lost lawsuits. In other words, they actually take seriously the fact that they're supposed to not impose burdens on religion, and they're supposed to work around it when they can. And one benefit I think everybody ought to be able to agree on about the massive, flexible, far-reaching administrative state is it's got a lot of tools and it can usually work around. And so I think we're seeing some evidence that agencies are starting to do that. I think that's a very good thing. It gives me hope that we don't have to have an irreconcilable conflict between administrative state and religious liberty. The administrative state, like any other government, can learn to live with religious diversity and without squashing people who happen to have an unpopular viewpoint. So I'll stop there.
Okay, good. Okay, thank you very much, Mark, and thank you for your paper. Just as a reminder, all of the papers that are new and available for this conference are on our website, so please do take a look at those. We are lucky, we are privileged to have with us one of those experts in a division that does deserve deference, and that is Justin Butterfield, who's the Senior Advisor in the Conscience and Religious Freedom Division at the United States Department of Health and Human Services. He is a graduate of the Harvard Law School and worked also at First Liberty Institute in Plano, Texas. So please take it away, Justin.
Thank you. So in reading Mark's article, I was struck by, I think, the rise in the administrative state and how that impacts religious liberty is something that I had kind of intuited but never really put it together quite as succinctly and as well put as Mark put it. I do think that it's heavily mixed, and as you mentioned in your article, sometimes it's hard to see exactly where the line between the legislative and the administrative is. And for example, that with kind of the what we've been using as an example of the administrative overreach, the contraceptive mandate, without the Affordable Care Act, there would be no contraceptive mandate cases. So they're often mixed, but I do think that as we see this congressional push of deference to the administrative state, and they tell the administrative state, we'll give you the outlines, you kind of fill in the details, that we're seeing that exact interaction, that interplay that Mark writes about. Presently, there are about 2 million federal bureaucrats. Since 1960, the number of state and local bureaucrats has tripled to more than 18 million. So you have about 20 million governmental bureaucrats in the United States. Between the early 1960s and the early 2010s, the inflation-adjusted value of federal grants for the states has increased more than tenfold. So we are definitely seeing a radical increase in the size and the dollars flowing through the administrative state. And I think that is an aspect of why we see the administrative state more and more as time goes on, being the portion of the government that is burdening people's religious exercise. I think there's another aspect to it that we actually touched on in the first panel, and that is what we referred to them earlier as the nuns are doing. Nuns, N-O-N-E-S again, not N-U-N-S, which confused me for the first part of the morning panel. I was thinking, why would the nuns be abandoning religious principles? But then it clicked, oh, N-O-N-E-S. So in the 1970s and 80s, there was an uptick in those claiming no religious identity, but it remained fewer than 10% in the United States. Since the 2000s, though, it's reached the teens, and as of September 2016, approximately 23% identify themselves as atheists, agnostics, or nothing in particular. So nearly 1 in 4 U.S. adults, and almost half of the nuns, about 49% of those people who identify as none, who were raised in a religion and are currently unaffiliated, cited that the main reason for their change was a lack of belief. So while there are nuances that were discussed this morning, there is still, I think, a trend line in the rise of the nuns that has an impact. And the impact that it has here is, as the administrative state rises, it increases, you expect that it's going to roughly follow the same sort of trends that the population in general has in terms of their religious belief. So you have an increasing administrative state made up increasingly of people who have no religious affiliation and often don't understand sort of that religious worldview. And so you can think of it as, even if as the administrative state grows, you can imagine it's sort of like the body politic is putting on more and more clothing. Imagine the administrative state as clothing. And if the clothing fits you really well, it can be easy to wear quite a bit of clothing and not notice it. But if your clothing doesn't fit your body, then you start to notice you have, your clothes rub against you and causes friction, and you start to see sort of the conflict that we're seeing now between religious organizations, religious people, and the administrative state. So this administration is dedicated to protecting religious freedom and avoiding some of those issues that have been coming up from the administrative state. As Timothy Taylor mentioned earlier, on May 4th of 2017, President Trump issued an executive order stating that we would vigorously enforce federal law's robust protections for religious freedom. And then in October of that year, the Attorney General issued a memorandum that was guidance for the agencies on how they could implement religious liberty principles, looking at principles from the religion clauses of the Constitution, RFRA, other analogous laws, RLUIPA, how agencies can apply those principles to themselves. Because you don't have to wait to be sued before you protect somebody's religious freedom. And we want to be proactive in doing that so that the burden of litigation is not all on people who are facing a religious burden. What we've done in HHS is, within our Office for Civil Rights, we've created the Conscience and Religious Freedom Division. Our goal with creating the Conscience and Religious Freedom Division was to bring our enforcement of federal laws protecting religious liberty into parity with how we enforce other civil rights laws. We announced we were open for business in receiving conscience and religious freedom complaints in January of 2018. And for an idea of how much demand there was for that, in fiscal year 2018, we received over 1,300 religion or conscience complaints. Of those 1,300, 343 of them were particularly conscience complaints. Compared with, in the previous administration, in the entire 8 years of the previous administration, we received 10 complaints. So just announcing publicly, these are the sorts of laws that we're here to protect. We're going to treat those, give those laws parity with other civil rights laws. And we had that huge, from 10 over 8 years, so 1.25 per year, to over 1,300 in 1 year, of which 343 are conscience complaints. At Conscience Religious Freedom Division, there's basically two sorts of federal laws that we enforce. You can think of them as the non-discretionary protections. These are things like the Weldon Amendment, areas where there's not a balancing test like we talked about earlier. It's Congress has said this is how we're going to protect conscience and religious freedom. So the Weldon Amendment says HHS cannot use certain funds in any way that discriminates against people who refuse to perform abortion, refer for abortion, et cetera. And we have several laws that are analogous to that, dealing with abortion, sterilization, et cetera. And we actually, just in January this year, had our first enforcement when we issued a notice of violation to California for California's Reproductive Fact Act, which is the Reproductive Freedom, Accountability, Comprehensive Care, and Transparency Act. It was the act that was struck down on free speech grounds by the Supreme Court in NIFLA. And what that act did was it required that if you were what they called a licensed pregnancy center, then you had to, and they kind of cut what they termed a licensed pregnancy center to follow their rules, you had to post a notice that you were unlicensed, but if you kind of agreed with the California ideology, then you did not have to post a notice. Also, if you were an unlicensed provider, you had to post these notices in all of your advertisements, and because it was targeting groups on the basis of their refusal to refer for abortion, and also based on some of the notices for some of those groups, effectively requiring of referrals for abortion, we issued that notice violation, finding that they had in fact violated the Weldon and Coates Snow amendments. This morning, we issued a notice of resolution for Hawaii's similar but different take on that, Hawaii Act 200. And we were very thankful that the Hawaii Attorney General, in response to our investigation, has agreed to issue a memorandum announcing that they will not be enforcing Hawaii Act 200. So those are sort of the non-discretionary protections, right? There is an absolute standard. If you do this, then Congress has instituted protection. There's also, as we talked about, the balancing test, RFRA, where we have to look at, is there a burden, a substantial burden on a person's free exercise of religious belief? Do we have a compelling interest? And so one of the things we've done at HHS is the Secretary has delegated to the Office for Civil Rights, Conscious Religious Freedom Division, authority within HHS to issue statements, make determinations as to whether internal HHS operations comport with the requirements of federal religious liberty laws like RFRA. You've probably seen our first finding under RFRA, which was we issued a waiver to the state of South Carolina after South Carolina had requested a deviation on behalf of one of their religious providers, Miracle Hill, that provides approximately 15% of the state's foster parent support. And the deviation was sent to ACF, the Administration for Children and Families, and they then sent a question to OCR. The state of South Carolina is requesting this deviation. How does RFRA impact this analysis? And so OCR looked at RFRA, we looked at Supreme Court case law interpreting RFRA and analogous federal statutes. We looked at the Attorney General's October 2017 memorandum regarding federal law protections for religious liberty. And we determined that forcing Miracle Hill, who was willing to refer anybody that they couldn't partner with to other agencies, forcing them to violate their religious beliefs to continue to participate, would in fact violate the Religious Freedom Restoration Act. And so we issued a letter to that effect. So that's what we are trying to do to avoid the growth of the administrative state and the continuation of the administrative state as it has grown for the past 40, 50 years from continuing to be narrowly, have that tunnel vision, the bureaucratic tunnel vision that this is the area and we're not going to consider any sort of countervailing interests, when in fact Congress has repeatedly said, no, we must consider rights of conscience, we must consider religious exercise, and so we're committed to making sure that we do consider those proactively.
Thank you very much, Justin. Next, we have Brianne Gorod, who is the Chief Counsel at the Constitutional Accountability Center. She has formerly practiced at O'Melveny and Myers. She also served in the Office of Legal Counsel and was a law clerk to Justice Stephen Breyer, Judge Robert Katzman on the Second Circuit, and Judge Jed Rakoff on the SDNY. So, Brianne.
Well, thank you, Andrew. And I want to start by thanking the Boyd and Gray Center and the George Mason Antonin Scalia School of Law for hosting this conference and for inviting me to participate. I'm really glad to have the opportunity to read Mark's paper. I think it's incredibly thought-provoking and interesting. There's, as we'll talk about, a lot in it that I disagree with, but I think it raises really important issues that are only going to grow more important, as he notes, and thus merits thought and discussion by people with different perspectives. And so that's why I'm so glad we're having this conversation this afternoon. There's obviously a lot to talk about when it comes to this topic, so I'm going to just focus on 3 of the paper's claims where I part ways with Mark. So I want to start where the paper does, and that's with Hobby Lobby. He observes at the outset that the claim that Hobby Lobby was unprecedented is, in his view, tenuous because he says the court has long embraced constitutional rights for corporations. Now, this argument obviously isn't the core of the paper, but it does set the table for it. And to the extent that we want to think about shifts that have occurred in religious liberty cases, as the paper rightly encourages us to do, I think it's important to step back and think a little bit about what a shift Hobby Lobby, in fact, ushered in. So Hobby Lobby was the first case in which the Supreme Court recognized religious free exercise rights for secular for-profit corporations. And this was, I think, actually a really stunning decision by the court. The First Amendment's explicit protection of free exercise of religion was intended to protect a basic human right, a basic right of human dignity and conscience. And that's why, from the founding to the court's decision in Hobby Lobby, the Constitution's protection of religious liberty had consistently been seen as a personal right, one inextricably linked to the human capacity to express devotion to some higher power and to act on the basis of reason and conscience. To think about it just a little differently, our Constitution was enacted, as its very first words make clear, for the benefit of we, the people. And at the founding, corporations stood on a totally different footing than living persons. They were mere creatures of the law, and so they only possessed the properties which their charters of creation conferred on them. So corporations, unlike individuals, didn't have fundamental, inalienable rights by virtue of their inherent dignity. And those were the rights that were codified and protected by the Bill of Rights, including the First Amendment. Now, it's certainly true, as Mark rightly notes, that corporate entities can assert some constitutional rights, and they've long been recognized to be able to assert some constitutional rights. But those have been chiefly rights related to their role as businesses. They can enter contracts, they can own property, they can manage their affairs. They had not ever been accorded all of the rights that individuals possess. And so that's why I think Hobby Lobby really was a market shift. And if we want to think about why we are now seeing this rise in religious liberty claims that arise from administrative action, Hobby Lobby, I think, is an important part of that story. So that's point one. And then second, I want to turn to what's really the core of the paper, which is how we should think about the role of administrative agencies in cases that involve religious liberty claims. There's obviously some suggestion, we've heard some this morning, it's in the paper, that there's something problematic or troubling about administrative agencies putting in place policies that arguably infringe on religious liberty. The paper talks about the burdens imposed by unelected administrative agencies. Mark talked this morning a little bit about how they're populated by specialists who, as he said in the paper, may not know about or may not care about competing religious interests. And there's also the suggestion that Congress may shirk its responsibility to make important policy decisions because it'd rather avoid difficult questions and just pass those questions on to administrative agencies. So he says, for example, it was not the democratically elected Congress that decided to require employers to provide health insurance coverage for contraceptives, but an administrative office within an executive agency. And explicitly says that sometimes it'll be the case that elected officials will prefer to achieve a controversial goal through agency action rather than legislatively. And these are the same kinds of critiques that I think we hear more generally from some about administrative agencies and their role in making policy in modern America. And so I want to push back against this general idea, and I'll make 4 points in doing so. So the first is that just because the people who work in administrative agencies aren't elected, that doesn't mean that agencies are unaccountable. So the president is obviously elected, and the president has considerable ability to set the direction of the administrative state. And that's why, as the article talks about, we've seen some administrative agencies approaching issues in a markedly different way over the course of the past 2 years than they were approaching them before. Second, to say that administrative agencies don't know or don't care about competing religious interests, I think gives short shrift to the process by which many, albeit not all, administrative decisions are made. Administrative rules, for example, are promulgated after a notice and comment process. So that gives members of the public and interested advocates the opportunity to raise religious liberty concerns. Agencies need to engage with those concerns. They need to explain how their final rule is responsive to those public comments. And so in some ways, administrative agencies, even more than legislatures, are required to engage with religious liberty concerns that might be raised by the rules they promulgate. And I think, Hobby Lobby is actually a pretty good example of this. As the Health and Human Services Department and the office within it that was promulgating the contraceptive coverage rule was drafting that rule, there was lots of consultation with faith groups to try to craft a rule that achieved the statutes and the agency's goal of ensuring that women could access contraceptive coverage without unduly infringing on religious liberty. And so that's why the rule had an exemption for churches and other groups, and then an accommodation for other religious groups. Third, I think it's important, as we think about the importance of religious liberty interests and making sure that those are taken into account when administrative agencies act, I think it's also really important to think about the value that is served by having specialists engage in administrative decision-making. There's a number of reasons why it is important to have agencies have specialists who really know the area in which the policy is being implemented. And again, I'll turn to the contraceptive coverage example. In passing the Affordable Care Act, Congress made a decision. It wanted to require coverage with respect to women of additional preventative care and screenings. It thought this was an important part of ensuring that all Americans had access to affordable health care coverage. And Congress recognized that women face different health needs than men, and that those different health needs often involved additional costs for women. And so this was a policy choice that Congress made, but it thought it was important to have, as it had in the context of other preventative care decisions, an expert administrative agency decide what exact services should be covered. And to formulate its recommendations, the Department of Health and Human Services, again, a specific office within that agency, consulted with experts, specialists in disease prevention, specialists in women's health, specialists in adolescent health issues, to make sure that they were covering the services that would be most important in ensuring that the statute's goal could be accomplished. And so these experts weighed both the religious liberty interests and the incredibly important interests on the other side. And I think it's important, too, not to forget that, right? That there are, as we're thinking about religious liberty interests, there are always going to be, or at least most of the time there will be, important interests on the other side that the agency is attempting to accomplish. In the case of Hobby Lobby, it was an incredibly important interest in women's health and women's bodily autonomy. And you can see that if you look at the litigation that ensued around in both Hobby Lobby and then in Zubik. In Hobby Lobby, for example, the American College of Obstetricians and Gynecologists, the American Academy of Pediatrics, so these are not exactly radical groups, they filed an amicus brief in the Supreme Court explaining just how important access to contraceptive coverage is to the health of both women and to children. The brief explained that pregnancies that are too frequent or too closely spaced put women at significantly greater risk for permanent physical health damage and can also have negative health outcomes for babies. And on top of that, they talked about how hormonal birth control has lots of other health benefits for many women, including reducing the risks of various cancers. And then fourth, I think there's no reason to think, and I'm going to talk again about Hobby Lobby specifically, that this was an effort on the part of Congress to evade responsibility for the policy choices that it made. when the Affordable Care Act was being debated and when the particular provision that required coverage for women's preventative services and women's health was being debated, numerous members of Congress emphasized that it would reduce unintended pregnancies by ensuring that women receive coverage for contraceptive services without cost sharing. This wasn't a secret. It wasn't something Congress was trying to hide. It was an explicit goal of the law that was being passed. And all Congress did was require experts, again, to identify the specific services to be covered, because that was how the Act was approaching preventative services more generally. Indeed, if you think about the contraceptive coverage mandate, despite the fact the requirement was put in place by HHS, popular commentary about the requirement, about the litigation that ensued, consistently referred to it as the Affordable Care Act contraception coverage. And so, again, I don't think there was any secret about who ultimately was responsible. It was the Affordable Care Act that was passed by Congress and signed by President Obama. And so the last point that I want to talk about, which Mark also talked about this morning, was the idea that there can be win-win scenarios, right? Because agencies have lots of flexibility in how they approach things, they will often be able to come up with rules that sufficiently protect religious liberty, while at the same time totally achieving the agency's policy outcome. And I think in some cases that's entirely right. I think the whole case that we've heard a lot about today is one possibly good example. As Mark notes in the paper, there were, this is again the case about the Muslim prisoner who wanted to grow a longer beard. Prison officials wouldn't let him do that. There were a number of ways to achieve the prison security interests that didn't require intruding on the prisoner's religious liberty interests. And that was the same exact thing the Supreme Court said. They noted that the prison already searched prisoners' hair and clothing. It already searched shorter beards that were allowed in response to medical conditions. And so there wasn't any sound reason why they couldn't simply search longer beards. But I think in many cases it may be more difficult to achieve this ideal outcome that Mark talks about, in which the agency can achieve its policy outcome without any infringement at all on what anyone might perceive to be their religious liberty. And so I want to close by just talking a little bit more about Hobby Lobby, because I think it is a useful example. Mark made the point that when thinking about how to ensure that women have access to contraceptive coverage, no one would think there's to go to the nuns, except that we live in a country in which most people get their health coverage and their insurance through their employer. We have a system that relies primarily on employer-based coverage. And while the Affordable Care Act created these new marketplaces, the fact is it left in place that most people get their insurance through their employers. And so there are some people who are employed by religious nonprofits who themselves want to be able to access contraceptive through their health insurance, just like they access all of the other medical services they need. So, Mark made the point that an alternative to women achieving this coverage through their employer health service insurance is simply for the government to provide it. In the paper, he talks a little bit more about how the Trump administration is now offering these products for free under Title X. So this is a federal grant program that's dedicated to providing low-income families and the uninsured with comprehensive family planning and related preventative health services. But I think it's important to tell the complete story, because there's a couple of other things that are going on here. So, one is that the Trump administration has also issued a rule that would exclude a lot of Planned Parenthood clinics from participating in Title X family planning program. And what that means is that it's not at all clear that Title X will actually be able to provide coverage to all the women who will not be able to get it through their employer-based insurance. The Kaiser Family Foundation and GW University found that few of the nation's community health centers would be able to handle that kind of significant increase in patients. And indeed, when Hobby Lobby and its companion cases were being litigated, this was discussed as an option. And the National Health Law Program at the time explained that Title X is the nation's only dedicated source of federal funding for safety net family planning services. They're not designed to absorb the unmet needs of higher income insured individuals. So it's not clear that this is actually going to be able to achieve what HHS set out to achieve and what Congress wanted it to achieve in guaranteeing that women would be able to have contraceptive coverage. And so just to finish up really quickly, I think that argument also misunderstands the real burden it imposes on women to not be able to obtain contraception as part of their normal health insurance. And this was something that was talked a lot about in the litigation that ensued immediately after the rule was put in place. But there are important reasons why you want to be able to access all of your health insurance and all of your health coverage through a seamless system through the insurance that is provided by your employer. All of which is to simply say that there are going to be lots of, I think, contested questions about the best policy outcomes and the ones that best balance the policy goals that agencies are trying to achieve and religious liberty interests. And that's going to be true regardless of whether we see legislatures or agencies making these decisions. So I'll close it up there and look forward to further discussion.
All right, thank you very much. Finally, we have Professor Adrian Vermeule, who's the Ralph S. Tyler Jr. Professor of Constitutional Law at Harvard Law School. He's the author of 9 books, most recently, Law's Abnegation from Law's Empire to the Administrative State. So please, Professor.
Great. I want to thank Andrew and Adam for having me here. Despite several kind invites from Adam over the years, this is my first time both at the Scalia Law School and at the Center for the Study of the Administrative State, so it's a real pleasure. I'm here as a scholar of administrative law who has relatively little focus in law and religion. I don't work in that field directly. In that way, I greatly enjoyed and profited from Mark's excellent paper. It seems to me the core descriptive observation of the paper must be right, and incidentally not inconsistent with what Judge Duncan said at lunch, that SCOTUS law has seen over recent decades an increase in the number of religious exercise cases in which the conflict was caused by an act of administrative authority rather than an act of legislative authority. It rings true and it fits the data. It's a little bit tricky to formulate the point in legal terms because there's an argument that there can be no such thing as an exercise of administrative authority in its own right. So we might have an antinomy where we say either the administrative act has or does not have legislative authorization. If it doesn't, then it fails independently of any religion-related issues. If it does, then legally speaking, the real cause is the legislative decision to authorize the agency to take that act. So on this view, there would be no such thing as an act of administrative power that should be classed as an alternative to an act of legislative power. Still, we know what Mark means and what he's referring to. There's plausibly been an increase in discretionary agency action that impinges on religious values, actions that, while authorized by statute, aren't required by it, and seem to rest on the agency's pursuit of a mission that is argued to be either heedless of or affirmatively hostile to religious perspectives. So I think the main observation of the paper is true and important. When we come to discuss the causes of the phenomenon, however, I began to be inclined to dissent in part. It seems to me that the paper might be read to assume that there's some intrinsic structural tension or conflict between the growth of administrative bureaucracy and religious commitments, such that the administrative state is mainly to be understood as a threat to religious values. Mark suggests, for example, that specialization is a structural cause of administrative conflict with religious values because agencies have a single-minded focus on a particular goal and therefore undervalue competing interests outside of their mission lens. But I don't see why this necessarily makes agencies structurally prone to ignore or discount religious values in particular. It seems to me that everything depends on what is defined as inside or outside a given agency's area of specialization and substantive mission. And my point would be, I think, substantiated if we had an example of a massive bureaucracy that is devoted to nothing other than the promotion of religious values. And my example is what is by many measures the largest and oldest continuous bureaucracy in human history, which is the Catholic Church. Here we have institutional specialization that's raised to an art form. That is, the Roman Curia, for example, is constituted by literally Baroque divisions and subdivisions of institutional specialization that makes the federal government's organization chart looks simple by comparison. One might say that the genius of Catholicism is precisely the marriage of bureaucracy with mystery. And the legal theorist Carl Schmitt once famously joked that Catholicism triggers special horror in the Anglo-Saxon mind because it combines two things that the Anglo-Saxon can't abide: bureaucracy and celibacy. So what matters then, I don't think, is specialization in itself. I think specialization is an intrinsically neutral institutional technology. What matters rather is the substantive content of the mission that the relevant bureaucracy is entrusted with. Now, it's undeniable that policymaking by our American bureaucracy has, for complicated reasons, come to be largely defined as a quote-unquote secular, liberal, technocratic enterprise. I've put secular in scare quotes because I think that this American liberal technocratic enterprise itself flows from a very particular set of recognizably religious commitments, whether or not its holders describe themselves as such. That set of commitments is an odd and very distinctive mix of Pelagianism and immanentized historical providentialism, and that when the bureaucracy carries out policies justified with reference to things like cost-benefit analysis, it's demonstrably engaged in a kind of faith-based initiative. But all that's a conversation for another time. In recent decades, as one and arguably both of the major political parties has come to be dominated by an increasingly secular urban bourgeoisie in this sense, it should be no surprise that we have seen agencies pursuing missions that are hostile to or at least heedless of religious values. The most striking examples of this, in my view, have not risen from autonomous mission-directed administrative action gone off the rails without political direction. Instead, they've arisen precisely in areas where the incumbent White House has had a clear ideological and political worldview that was implicitly or explicitly communicated to and pursued by the bureaucracy. And in this regard, I think I'm in agreement with Brianne from a very different perspective, no doubt, but in agreement about the institutional phenomenon. I would suggest that the policy choices related to the contraceptive mandate that led up to the Zubik episode in the Supreme Court, as well as the Solicitor General's notorious warning or threat during the oral argument in Obergefell that the administration would consider denying tax exemptions to faith-based universities, both fit this description. So the administrative state, in my view, is an institutional technology that can be put to good or bad ends. It's no more intrinsically hostile to religion than, say, the use of written rather than oral communication. So as a kind of complement or counterpoint to Mark's paper, then, I want to very briefly envision a different relationship between bureaucracy and religion, one in which bureaucracy could be seen as a useful positive instrument for the promotion of religion rather than only as a threat. Again, I by no means deny it can be a threat, just as a kitchen knife that serves the family can accidentally cut people and can even be deliberately turned to bad ends, but we still keep knives in the kitchen. So let me distinguish two ways the administrative state could be put to beneficial use to promote religious values. One is by clearing away legal and economic obstacles to religious practice, obstacles that are thrown up by other sorts of institutions. The other is by directly and affirmatively promoting religious values. Under the heading of clearing away obstacles, we might find the work of bodies like Justin's office and HHS, or similar bodies elsewhere in the administrative state. We can imagine the Department of Education monitoring universities, schools, and local school boards for hostility to religious values. All the quasi-coercive apparatus of the administrative state that libertarians love to hate, so things like dear colleague letters, interpretive rules, hour deference, implied threats to cut funding, vague but ominous warnings, all these things could be brought to bear on recalcitrant universities and other institutions that threaten the religious exercise of students, faculty, or other constituents. An inspirational model here is the executive order signed on March 21st requiring universities to respect free speech principles on pain of losing funding. With respect to the for-profit sector, consider cases like Patterson versus Walgreens, just granted by SCOTUS. in which the question is whether a firm may require an employee to appear for training on a Saturday in violation of the employee's Sabbath devotion. There's no reason why relevant federal agencies can't use their array of instruments to nudge employers to grant generous accommodations in such situations. And I think we heard fascinating talks on the details of this sort of thing from both Timothy Taylor and from Justin just now. Under the heading of affirmative promotion, we can imagine a variety of initiatives that might bring faith-based perspectives to regulation. Apart from program-specific offices, one might think more ambitiously about a general executive order folded into the existing executive orders governing OMB and OIRA that would require all agencies to consider religious values when regulating, just as they were instructed by President Obama's executive order to consider vaguely defined values favored by the religion of humanity, namely, quote, equity, human dignity, fairness, and distributive impacts. So this would amount to something like an expansion, clarification, and more direct application to OIRA of President Trump's executive order on religious liberty from May 2017 and the subsequent implementing guidance from the Attorney General. The maximum program, at least the maximum that could be imagined, I think, within the confines of our current institutions for now, might be a day when the law of judicial review of agency action itself builds in scope for administrative promotion of religious values above and beyond statutes like RFRA. The possibilities are manifold. I'll just mention a couple. We might imagine a general substantive canon of construction under which statutes would be construed where fairly possible, not to encroach on religious values. I think this would be no more or less justifiable than any number of other substantive, value-laden interpretive canons in our law. Under arbitrariness review, likewise, we might imagine a world in which agencies would have discretion to appeal to religious values as justifications for agency action, where statutes are otherwise silent or ambiguous. If, as a number of administrative law scholars now believe, it's legitimate for agencies to appeal to the political philosophy of the incumbent administration, it's hard to see why religious values should be on a different footing. Such values are, in my view, part and parcel of every political philosophy in one form or another. As Henry Edward Manning argued, all political conflict is, at bottom, theological. I merely throw out these speculative possibilities as discussion fodder. I do think they're within the range of the imaginable, however remote from current law they may or may not be. Many stranger metamorphoses have occurred in our law over the decades and centuries. However plausible or implausible such a possible future may be, the existence of the possibility itself just demonstrates the point I want to make, that the administrative state and its accompanying law are orthogonal to rather than intrinsically opposed to religious values. And in the right hands, the administrative state can be put into service in order to promote those values. Thank you.
All right, we'd like to leave plenty of time for questions, but I will first give Professor Rienzi a chance to perhaps respond to anything that may have come after his talk.
Sure, and I won't take too much of that time so that we can have questions and discussion. For just, I guess, to go in reverse order, ultimately, I actually don't think that there is necessarily an intrinsic conflict between the administrative state and religious liberty. I think there are some ways in which it, maybe only in recent times, but it seems, at least that the American version of the administrative state, in some ways seems more likely to bump into religion. But I certainly agree with the observation by both Adrian and Brianne that the contraceptive mandate was not an agency off on its own run amok. It was obviously directed by the White House. I think it was obviously directed by the White House for directly political and election-related reasons. But I think it was obviously done from the White House. So I agree. I'm not saying that agencies are unreachable or uncontrollable by elected leaders, and I'm not saying that they must do bad. I think there are many ways in which specialization can be good. As to the, on Hobby Lobby and on the availability of win-win resolutions, one, I'll just point out on the question of whether the organizations in those cases were able to exercise religion. we've had corporations able to exercise rights, many different kinds of rights for more than a century. Very old cases, but just take some that are only like 50 years old. There's New York Times versus Sullivan, right? It's not the exercise of right to contract. It's the exercise of the right to the free press and to free speech. They're a money-making corporation. They don't actually have a mouth, but they're able to exercise a speech right. Or if we think about a lot of the ways in which religion gets exercised, some of it is individual person praying or believing. Much of it is organizational. Right? I work for the Catholic University of America, which is a corporation. A lot of the Supreme Court's religious liberty cases do involve corporations. The Church of the Lukumi case, the actual full title of that is Church of the Lukumi Babalu Aye Inc. No one ever gets to the ink. I never noticed the ink until Hobby Lobby. But the point is that we've long actually allowed people, either individually or in groups, to exercise constitutional rights. Planned Parenthood, for goodness sake, is a corporation. I don't think anyone seriously doubts that Planned Parenthood can exercise rights under the 14th Amendment protection for persons. Planned Parenthood is a group of people organized in a certain way. So I guess I'll just end with saying there were actually only 2 justices on the Supreme Court who bought that side of the argument. If you read the dissents closely, Justices Ginsburg and Sotomayor thought that businesses couldn't exercise religion. Justices Kagan and Breyer, both at the oral argument, seemed quite skeptical of that and then did not sign on to that part of the opinion. So it's a claim that did not come all that close. As to whether there really are win-wins here, I'll just point out that both in the Hobby Lobby litigation and since, the opponents of the religious liberty claim have been really, really low on actual people who can claim that they've suffered. Actual people who say, I wanted this health insurance and I didn't get it. Hobby Lobby has tens of thousands of employees. You would have thought that somebody would try to get some of them to show up in an amicus brief and say, I want this and I can't have it. Maybe they were all scared. I'm sure that's the answer, is that, well, you don't want to go against your employer. But there are hundreds of employers filing lawsuits against the contraceptive mandate, hundreds of them in cases all across the country. I think the other side came up with 2 or 3 students at Notre Dame, and that was it. And those students, let's be honest, are eligible to be on their parents' health plans because they're under 26. So the fact of the matter is, this is one where the win-win was really easy. Governments from the dawn of time, or at least the dawn of modern time until 2012, had no difficulty making sure contraception was widely available without involving religious groups. This is one the administrative state should be able to solve pretty easily. Why don't I stop there?
Okay, so I'll just ask one quick question because it was the question that I was going to ask even before Professor Vermeule raised it, which is cost-benefit analysis. And I guess, all of these cases are lawsuits sort of on the margins, but for the bulk of administration, you're dealing with routine day-to-day things. So I guess my question is, at an agency, or how can you incorporate religious values? How can you incorporate conscience? And how can you balance that against monetary considerations? Could an internal directive at HHS coming out of your office, instruct your regulatory economist how to take these things into account? How ought that be put into play to take seriously the religious values?
Yeah, so it depends on what sort of, our view is it depends on what sort of statute we're enforcing, right? So if you have, I talked about the discretionary versus the non-discretionary versus statutes that provide some sort of balancing test. So if you have an absolute prohibition on a certain sort of discrimination, then you don't, are we going to perform a cost-benefit analysis before we decide, is it really worth it to follow Congress's instruction to us with respect to preventing discrimination against people who refuse to perform abortions? And the answer is the statutes that Congress has enacted don't call for any sort of a cost-benefit analysis. It's just that this is forbidden conduct. You can't do that. And so that's how we treat it. Now, under RFRA, we have the compelling interest test. And so whenever you get a claim that's not covered by one of those conscience protection statutes that clearly determine the outcomes, you have to determine, is there a compelling interest in what whatever this governmental burden is? Or is there another way to go about it that's less restrictive? And there are limits to the sort of, it's not just to put two weights and look at the dollar values. I think the Supreme Court in Hobby Lobby was pretty clear that it's not well, dollar here, $1.50 there, $1.50 there wins. But there is an aspect of the balancing test in at that initial look at, is there a compelling interest? Now, some of that gets pulled back once you then go to the next step of, is there a less restrictive means? But that's where that sort of analysis would come in.
Sure. All right. We can go to the audience for questions then.
Thank you very much. I think this question is probably more for Ms. Garodin, Professor Vermeule. As you were making your points, particularly about the scientific research and the importance of women receiving certain types of health care, and I was listening to it and reflecting on the arguments that were made on both sides at the time of the case, that a lot of times that information, though, those concerns were deployed, and implicit to those arguments was that we are asserting science as an objective value that objectively says these things are good and necessary over and against a non-scientific, non-rational, religious concern with violations of conscience. And I think that ties into the point that Professor Rienzi made and the point that I think Professor Vermeule came with, that it's not necessarily specialization at an agency that is the problem, but specialization as a technocratic view that lionizes science and scientism as the only way of determining what is right, and that oftentimes the kinds of experts that end up at agencies have that bias unintentionally, perhaps. But I just wonder if you could speak to both of you can speak to sometimes the implication that science and reason should always take precedence over religion, and the possibility that that implicit sort of bias resides often in the kind of expertise, or it can result in blinders being on experts that leads them to discount religious values that are important and should have an equal footing.
So, I mean, I don't think that anyone is saying that there is an automatic trump, but I think what the agency recognized as it very carefully considered how best to achieve the goal that Congress set out, which was to provide preventative services to ensure that women's health care was comprehensive and that women weren't paying more for their health care coverage than men. In making that decision, they recognize that their science is real. Medical experts understand what types of preventative services need to be provided for the benefit of both women and children's health. And what they did was think about how to make sure that aim could be accomplished with, I think, a good deal of sensitivity to the religious liberty interest on the other side. I mean, I think that's why it's important that there was consultation in the development of the rule with faith-based groups so they could understand their concerns, think about how best to accord those concerns value. And I think through the rulemaking and then through the litigation that ensued, the government was always quite respectful of the interests on the other side. The question was how best to balance the interests on both sides, and that's why there was an exemption, again, for churches, and that's why there was an accommodation for religious nonprofits. I mean, I think it's important, we've kind of thrown around the terms Hobby Lobby and Zubik as if they were the same issue, but of course in Zubik, the question was simply whether these religious nonprofits, whether it was a substantial burden on their religious exercise, for them to sign a form saying that they wanted to opt out and have the coverage provided another way. That's the only burden, such as it was, on their religious exercise. And obviously, I understand that the view that it was a burden was sincere. No one's questioning that. But that was the burden, and the agencies made, I think, the right determination that weighing that burden against the very real aims they were trying to accomplish, and the recognition that this was the best and most effective way to accomplish them. The rule that was set out was the right one.
But it seems to me that there's a chicken or egg problem, because the very fact that they got overturned by the Supreme Court suggests to me that there's something defective in their cost-benefit analysis, right?
Well, I mean, I guess two things. I mean, one, I don't think I would think of this circulating a cost benefit. That's not quite the rubric that you use in analyzing this. I mean, the other thing is that Zubrik obviously came to the court at a unusual time. That was an 8-justice court. You obviously don't know exactly what happened, but there was some sense that the court maybe couldn't quite resolve or determine how best to resolve the case, and so they threw it back to the lower courts. So I don't think that's quite the same as a Supreme Court determination as to who was right or wrong in that case. But obviously, the court will also make determinations that are Supreme Court precedent, but that, from my vantage point, weren't necessarily right. Hobby Lobby being one example of that.
Yeah, so I have a worldview in which the world is full of genuine, irreducible conflicts of values. And I think that's true in the administrative state as well. And I think in this regard, I agree with Brianne when she said that some of what might be thought of as win-wins aren't exactly win-wins, that there are, at the end of the day, genuine, irreducible trade-offs and conflicts between different considerations. Where I might quibble with your frame is I reject the frame that this is a set of conflicts between secular commitments on the one hand and religious commitments on the other. I think it's a essentially theological conflict between two different religious worldviews. One that embodies this very distinctive American liberal mix of Pelagianism and providentialism, and that worldview attempts to maximize at all costs the sort of autonomous decision-making of the individual in context after context, and that's its kind of deep faith commitment, and that leads it into conflict with other kind of religious worldviews in various areas. So, yeah, I think the conflicts are real, and there's no way to arbitrate them. At the end of the day, you have to choose. And my point about the administrative state is that it's nothing about it is intrinsically committed or wedded to the American theology. It can be pressed into service for all sorts of theologies.
And I think that both the points that Adrian and Brianne are making kind of goes to the analogy that I'd given earlier about how the clothes of the administrative state fit. And I think that your example of the religious exception versus the accommodation is actually particularly instructive on that point. So HHS got comments back, and then as a result of all this, they established sort of two tiers of religious protection. If you're a church, you get exempted from the contraceptive mandate. But if you're a religious nonprofit organization like Little Sisters of the Poor, you don't get an exemption from it. You get the accommodation. And so I can't obviously speak for all the plaintiffs in that litigation, but I don't know of any that actually objected literally to signing a paper. Their objection, from my understanding, is more that once they signed the paper accepting the accommodation, they then had to do things like provide their employee lists so that either the third-party administrator or their insurer could provide that coverage, and they, as employees come and go, they had to continually update their third-party administrator and their insurer so that those employees could get the objected to coverage. And it was not, if you'd said, sign this piece of paper saying I object, and they therefore were exempted, I don't think you would see the opposition to it that you got from sign this piece of paper and continue to update us with all of your employee status so that we can provide, therefore, that contraception coverage. I think that that's a very different sort of thing. But I think that the reason it was viewed as, they're objecting to signing a paper, actually goes to that do the clothes fit art sort of discussion that the administrative state the people who were involved in that, and I don't know who was involved in that particularly, but I would imagine they did not understand the actual religious objection that was being made by the religious objectors. And so they may very well have been trying their best to sort of match the exemption they were creating to the religious objectors, but because there was that divergence in worldview, it was lost in the translation. As a result, you had the conflict between the religious nonprofits and HHS saying, well, our accommodation is sufficient, we listen to you, and the religious nonprofits are saying, no, you completely missed the point.
Yeah, I guess the one thing I'll add is that I do think we've had in this country a long history of religious accommodations that allowed religious objectors to effectively opt out while facilitating others or facilitating the government pitching in and taking their place. I think a great example of this are conscientious objector exemptions to the draft laws. Going back to the nation's founding, our country had a draft and would let people who had a religious objection to participating in war exempt out, but they often had to pay a fine. At times, they've even had to help the government find someone to take their place. And so I think, one way that some viewed it in trying to craft this accommodation was that they were essentially doing the same thing that has been done throughout our country's history as a means of accommodating religious objection.
And I'll just say that, as to the historical point, it's certainly true that some of the founding era draft objections required somebody to pay for a substitute or otherwise pay a fine or do some other substituted service. But we really haven't done that in this country for draft and military service for, I think, at least since before World War I. And that's not the way we do our exemptions for people who work in the federal government, don't want to participate in capital punishment, or people who can't participate in abortions. Ultimately, I agree with what Justin said. It wasn't really about signing the form. It was that the consequence of signing the form was that you were allowing somebody else to take over and use the health plan that you bought and were required to create and give people. That had to become the vehicle to give out things that violated your religion, and that's why folks objected, and that's why they ultimately won.
Do you have any other questions?
Professor Vermeule, you said something kind of interesting in passing along the way. You referred to cost-benefit analysis, and I think you called it a faith-based initiative or something like that. Yeah. But it got me thinking, because I'm often struck by something that Justice Scalia wrote before he was Justice Scalia in '81 when the first cost-benefit orders were coming up. And he warned in a letter as ABA chairman, I think, that reducing the rulemaking process to cost-benefit analysis in the executive branch would really reframe, maybe deform the way that people think about rulemaking. They wouldn't think about it as value choices. They'd think of it more as sort of scientific analysis. And so I'm just curious for your thoughts, and anybody else on the panel, whether sort of the rise and entrenchment of cost-benefit analysis either has contributed to the conflict that Professor Rienzi is sketching out, or whether it didn't. I'm just curious if you think there's any relationship between the increasing focus on things like cost-benefit analysis and the way that Professor Rienzi argues you have administration coming into conflict with religious belief.
No, I have to plead ignorance. I don't know enough about cost-benefit analysis and its history, so.
I think that's a great insight, Adam, and I'd say basically yes. Partly because cost-benefit analysis is a real tool that can have real uses when there is agreement on values, agreement on the content of the variables to be plugged into the analysis. The danger with cost-benefit analysis is that it masks disagreement over values with a kind of false technocracy. And I think that what sometimes happens with agencies is that in the grip of this false technocracy, they think they are doing something that simply promotes overall welfare, when in fact they are choosing, without knowing it, choosing between and taking sides in fundamental conflicts over theories of the good. And that's in political theory, that's a standard critique of liberalism, and I think cost-benefit analysis is where we actually see it happening.
Could we just set up an agency that answers questions of substantial burden, and wouldn't that just end all of these problems? Could it be your office, Justin? Sorry.
Each religious liberty complaint is always a very kind of fact-specific. Could you have an administrative agency that sort of, had for the purpose of what the administration is viewing, we're going to issue opinions on every fact situation that comes from us, and you refer it to them? Sure, I guess you could. I think that would just be kind of an extra layer. I'm not sure the benefit you would get from that, but I guess you could.
Can I just say, and if you look at every regulation you've ever seen issued, there's like 7 pages at the back about the Paperwork Reduction Act. So like, they add a bunch of pieces of paper to tell you how much they've thought about making sure they don't waste any paper. And for a lot of government projects, they have to do an environmental impact statement before they do it. So it's not at all out of the ordinary for the government to say there are some values that are important and that we think you ought to look into them and think about them before you issue a rule, and whether it's a separate agency or just DOJ or something like that. The bottom line is respecting people's religious exercise rights and speech rights and right to be free from other kinds of discrimination. These are obligations that agencies have, and one way or the other, they really ought to think about them before they make law. That's their job.
Hey, just a few things to throw out. During my brief tenure at HHS, there were so many epidemiologists and public health specialists, but I was really quite shocked at the shortage, almost non-existence, of real practicing physicians. Just a real bereft of any practical experience. And I bring that up because I wonder about this term expertise, and if the experts are actually being informed by practical experience with real human beings. And then the second thing, with respect to the public comment, it did seem during my experience that was a little bit rigged. The people who were inside the system were able to alert interested parties to participate in the public comment. So I'm not sure how authentic that was, a reflection of public sentiment. So I'm just throwing these things out. And the last thing is that this idea that as long as everybody can get something that I consider immoral, they can get it, I won't have to provide it. But the minute that people cannot get it, well, then I will have to provide it. That's sort of a precarious foundation on which to rest religious liberty rights. So just throwing that out there.
Go ahead.
I was just going to say, I guess on the, whether they're actually consulting with real experts with practical experience. I do know in the Hobby Lobby context, we're obviously experts in the agency, but they also consulted with a number of groups and experts outside the agency. So I can't speak, I wasn't in the agency, I can't speak with particular granularity, but I think that was certainly the goal, was to speak to people who could really have knowledge on what were the preventative services that needed to be covered. As to public comment, it's certainly true that there are some advocates who are going to make sure that they are commenting whenever there's a new rule that's promulgated that's of interest. But what's great about the notice and comment process is that it is a process that is truly open. Anyone can comment, and people should comment when they have views on proposed rules. And when they do, the agency needs to engage with those rules. So I think it does certainly provide a possibility for those who are concerned about the religious liberty implications of a proposed rule to engage and to force the agency to really think about it before it acts.
And I'll just say on the comment about the precarious position for religious liberty as being so long as somebody else can get it, then you don't need to restrict religious liberty. First, my own view, and this is a place I think I differ from both Adrian and Brianne, is I think the truth is that's actually the vast majority of things. I think it's pretty hard to come up with things that you say, I really need to force this person to violate his or her religion. There are cases like that. Hosanna Tabor is a great example of a case like that, right? Somebody actually really lost something there. Cheryl Parrish, if she worked someplace else, would have been able to have an ADA claim. She didn't because it was against the religious school that she worked for and where she taught religious studies to the kids. So it's not that religious liberty suddenly loses if somebody else has to lose something, but it is to say that in a world, particularly with RFRA, and particularly with our massive administrative state that has so many ways to get things done, the cases where it really is a zero-sum game are few and far between, and the vast majority of them are ones where if people have good faith, there really are ways to work around the religious objection.
All right, well, with that, I'd like to thank the panel for an excellent discussion, and thank, again, Professor Rienzi for his paper available online. So we'll take a 10-minute break, and we'll be back soon.